Good afternoon. My name is Don Vivrette. I thought for Pete and Trevor, we ought to have this as our lead into it. So welcome to the session. Let me go through a couple of things and then we will have Pete and Trevor come on up and go through the rest of this. It's your state today. It's week 7. We have one more week to go. This is going to be trustee and executor duties, which is critically important to people in terms of what they're doing and what's going on. As before, I want to raise the issue in terms of where the materials are, and it's material at itsyourmoneyandestate.org. That is in the reminder that you get every week, so you can see that also in terms of where that is. The videos are there, and any other supplemental materials and whatnot that we have put all of those into there. I've lost my mouse. Oh, there we go. Oh, back up, too fast. Okay, when you go into that site, what you will see is, may bring you into It's Your Money. You can then click and go either to money or estate. Go on, scroll down through the various weeks, and you will find the material. In this particular case, he's there, right there. So normally what we've done is to put the video on top of what's going on. And so you can see those of where the videos are and how they will play through, as well as any handout material. And from here, you can get to money or estate. These are the charities that we have participating with us. We have a tab called Sponsor, which lets you click on those and go to their website or get other information from them. We are doing trustee and estates. Next week, we'll do a case study and a review and wrap that up. Next week for money, the day before, next Tuesday, will be It's Your Money in Your Mind, and wrap up also with that one. So that will end our 8 sessions when we get there next week. These are the set locations that we are normally in terms of physical locations that we would go to. So you can see all of those. And as I have said, I dearly hope that we are able to be there in person in the springtime, because it's a lot better doing this live. These are the various participating charities. Shout out again to Chapman for their 10 years of continuing sponsorship for the organization and for these presentations. That is very valuable to us and helpful. With the charities, typically, they would be physically here with us and do about a 5 to 10 minute presentation. So that obviously didn't work out this time. So today is Susan Komen, and we're going to play a video that they've provided. So I will switch over to that one, and hopefully that will all go very smoothly. So let's see how we go, and that. Yes, I talk to myself as I go.
I was 14 years old, 8th grade, when my mother was diagnosed with breast cancer. My mom would give me these gigantic hugs. She'd come up to me and just give me these giant hugs and just hold on to me like her life depended on it. And I was young, in my teens, and I would hug her back, but then after a few seconds, I would say the things teens say, like, "Come on, Mom," and I'd sort of squirm away. But then I remember one day I was maybe 17 or so. My mother comes up to me, gives me one of these giant hugs, and I hug her back. And as I start to squirm away, that's when I realized the importance of these hugs, because I felt her tears rolling down the side of my face. And that's when I realized my mother has been hugging me as if it could be our last hug ever. And from that point on, I always held her back, and I kept holding on to her because I knew one of these days it would be my last hug with her. In my high school prom, I'm 17, I'm a senior in high school. We're driving to the prom, and on the way there, I asked Lisa if she would mind if I stopped by to see my mother at the hospital. And she said, of course. We turn around, we go the other way, drive 20 minutes to the hospital. I park out front, I run up to my mother's floor, and now at this point, my mother was in her last stages, and she had been on a lot of drugs. She hadn't been coherent in weeks. I walk into her room, and of course she was sleeping, and I give her a kiss on the forehead, and almost miraculously she wakes up. And not only that, but she actually recognized me, which I was totally surprised. And she tells me she'd never seen me in a tux before, which was true. And then she did something which I loved. She was a little feeble, but she reached up and straightened out my bow tie. So, moms will be moms. And I told her I was on my way to the prom. So I wrapped my arms around her, and this time I gave her a big, gigantic hug. And while I'm holding her, I just kept telling her over and over again, I love you, I love you, I love you, I love you. I just kept saying it over and over until she fell asleep. I love you, I love you, I love you. And then she fell asleep in my arms. And that's the last time I ever saw my mom. Once my mother passed away, one of the many legacies she left was to continue her fight against breast cancer. Times have changed over the years, and I think there has to be a social good connection to everything we do in business. So this year, we decided to do something a little bit different with a philanthropic theme. We wanted to raise awareness for breast cancer and the good work that Susan G. Komen is doing in the world. We wanted a brand name because if we're going to ask a room full of hundreds of people to donate money, we need to make sure this is a brand that's well respected with the highest reputation possible. But we came up with the idea of having a couple speakers talk about their emotional connections to breast cancer. And then I would get up on stage and just very simply ask everyone to stand up and each donate $1,000. So the next morning at 10 o'clock in the morning was our 20-minute session devoted to breast cancer. We had a couple different speakers. We had Laura Logan, who was the 60 Minutes correspondent. She spoke. And then we had Heidi Floyd, and they were both excellent speakers. I know there's people in the audience crying because I see them sort of dabbing their eyes and taking their glasses off and wiping their tears off. I had 2 minutes to make the ask, and I make the ask, but who would like to stand up with me in the fight against breast cancer? And I sort of held my breath, and there wasn't a hesitation. People immediately stood up, and I looked across the room and saw really the entire room stand up, and I sort of thought to myself, Mom, we did it. We did something you'd be really proud of.
And so, Pete, if you wish to join me.
Hello, Don.
Do you want to answer the question of was there any significance to the picture of you and Trevor at the beginning?
Yes, it was
a staff meeting that you
final
had.
exam before we got our fiduciary license.
I just thought it would be fun. That's the only significance to it. And so, whoop, where we go? Trevor's here. Trevor, turn on your camera.
Okay. Before we introduce Trevor,
before we do that, I'm going to go away because I keep track of the question and answers. And so I'm going to turn off my camera and I'm going to turn off my microphone and let you guys chat, and I will ask questions as we go. Bye.
Bye-bye, Don. I thought it was a moving video by the Susan Komen because when you lose a parent for a particular disease, and especially at that young age, it has just an enormous impact on you. And one of the reasons why I started the workshop series was because my father was in the hospital on a ventilator for over 6 weeks, and we didn't have any estate planning documents completed. And I wouldn't want that to happen to anyone else. And so it helps having an outlet for this kind of thing. And if, one of the things he died of as well was rheumatoid arthritis. And I'm including rheumatoid arthritis in my estate plan. And it helps me feel good that I'm doing something to remember him. Anyway, passion and emotions are good things. And I hope you appreciate the different charities that are sponsors of the workshop series. Before I introduce Trevor, I want to just kind of briefly go through what we've been through so far. yeah, we talked a little bit about taxes, and absolutely taxes are important in the first class. But the most important thing from the second class is you need to understand how you have titled assets. And we're going to go into some of that today, because depending on how you have titled assets, it determines who wears the hat to have the legal authority to act on your behalf. So we're going to get more into that. We also talked about the Advanced Healthcare Directive and the durable power of attorney as far as incapacity is concerned. So if you just want 3 documents, make sure it's the Advanced Healthcare Directive, the will, and the durable power of attorney. We got also into the living trust, how valuable the living trust is. It can help you avoid conservatorships. If you suffer from some sort of incapacity, the person you chose, and we're going to talk about that today, steps in, and it's seamless. And that's the way it should be for somebody to take care of you. We had a special session on charitable giving and retirement planning. And those assets, again, are handled completely different than your other assets. So let's get into being a trustee and an executor. And my Ask First form was in the very first session. So I'm going to introduce Trevor. Trevor is a partner with me in professional fiduciary services. So I'm going to introduce him using his Ask First form. What's your master's or other advanced degree in, Trevor?
I have a master's in foreign service from Georgetown University. So essentially a master's in diplomacy.
And that's pretty good. Tell me a little bit about your background.
Well, I have been, for the last 7 years, I have been a private professional fiduciary. I have been licensed by the state of California in that field for the last 5 years. Before that, I was an executive director of a large charity in Costa Mesa, and then before that, I was in I worked for the State Department in DC, and then before that, I was in the Peace Corps in East Africa. So a lot of different experiences over my.
And you have 2 adopted kids?
I've got 2 adopted children from Guatemala, beautiful, 2 little beautiful girls. Yeah.
Okay. Credentials, you got your master's, you got your economics degree from Berkeley, you got a certificate of trust from CSU, and the elder mediation training. A great background to be a fiduciary. Relevant licenses. Talk a little bit about your California licensed professional fiduciary.
Well, we're going to go into that just now. We're going to show everyone the website from the Bureau, but essentially I am licensed to serve in all the fiduciary positions in your estate plan, meaning your successor trustee, your agent for your healthcare directive, your agent for your power of attorney, the executor in your will, and so forth. And in order to do that in California, for I think 3 or more cases that are not family, then you need to be licensed.
Yeah. So yeah, and we'll talk a little bit more about that as we go through this, because it's very important. Whoever says that there are professional fiduciary, that you look them up just like you do attorneys on the bar search, just like you would a financial advisor on broker check. You need to check the people out that you potentially would hire. You don't practice law,
no,
and you serve as a fiduciary to all your clients?
I do.
And how are you paid, Trevor?
Well, for trust administration, I have a fee schedule. Just to clarify, even though we're partners, each of us are licensed as individuals, not as a company. So we each have our own fee schedule for the cases that we work on. I have for trust administration, my base fee is about 1% of the assets that are titled in the trust. That does not include you know, your retirement accounts and all that, which pass through beneficiary designation. And that's valued at the date of death usually. I have an hourly rate for incapacity positions of $195 an hour for power of attorney and agent for healthcare directive. And then if I'm administering a probate, those fees are statutory and determined by the probate code.
Okay. So, and then you're not associated with anyone who sells insurance, annuities, mutual funds, or financial products.
I'm not associated with any of them.
Okay. Okay. All righty. Let's go to, you want to talk a little bit about, let's go to the first slide.
Well, I think we're going to go to the, do you want to go over the, this?
Okay.
First?
Sure.
Yeah, because I think you had mentioned before, a lot of people are unfamiliar with this as a profession.
Yeah. Well, California is only one of 2 states in the country that has a licensing requirement for professional fiduciaries. And this came about 15 years ago. And so it's not that old. And, but this is the website, fiduciary.california.gov. And where does a person click on to figure out who in Orange County, for example, they want to go to?
That's a good question. You can see how you can go to license verification here on the side. You can see my arrow. Click on that, and you'll come up to a license search. Now, this is very important. Just like you'd look up an attorney on a state bar or a financial advisor on broker check, it's important that you may want to look up, you know, the fiduciaries and what they're doing. The easiest way and to get the most filtering is you go down to this advanced search first. And this will all be recorded, remember. You can go back and see if you forget. So don't worry if you don't get all this. It says Border Bureau. You'll see all the people or all the different licensing boards. Go down to professional fiduciaries. And then you can see how you can filter by city or county. We're going to filter by county and go down to Orange. Whoop, passed it. There you are. And then it also has the status of the license. Some of the licenses have been canceled. Some are inactive. So we're going to want active fiduciaries in Orange County. And then we'll hit search. Okay, and you see it'll filter, and it looks like, wow, there was 2 more since a couple of days ago, Pete. But we have 78 active licenses in Orange County. Okay, and
well, let's go to the one revoked.
Oh yeah, there's one revoked. So let's say I'm going to take off the active. And then there is a revoked license. Okay, so here's someone who's been revoked. Sorry, your picture's in the way there, Pete. Okay. So you can see where his expiration date tells you when it expired. It tells you his license number. If you go over here to more detail, you can get a lot more information about perhaps why it was revoked. Here's his fiduciary. We have to, as fiduciaries, we have to report all of our client assets every year to the Bureau, the total amount that we have under our current management. Okay, and it tells you if you had a bankruptcy or anything removed. Now, there's
the total client assets is a number that's pretty important. It kind of tells you kind of their experience.
Exactly. It tells you how experienced they are, and it also tells you, you know, how busy they are if they have, you know, so many under management. So you're going to want to look at that. Here's some documents that explain perhaps why it was revoked. Yeah, it looks like he didn't pay his or didn't do what he was supposed to do. To keep our licenses active, we have to complete 15 hours of continuing education every year, and we have to, like I mentioned before, we have to report all of our assets to the Bureau. So this is just an example of
professional fiduciaries.
Yeah, and I think and I think that's a good, something that people should know, is that there is some consumer protection here when you hire a professional fiduciary, because there is a bureau that is looking after our license. A lot of people think, oh, you're just one person, you're just this lone wolf, nobody's who's watching over you. Well, if you have an issue with your fiduciary, you can call, or you can file a report, and they will investigate.
Okay, why don't you go ahead and bring up the outline, and I'm going to talk a little bit about, because most individuals are going to hire family members. And so, the question becomes, who can be a fiduciary in your estate? And literally, it could be any 18-year-old and above. So it's wide open. Yeah. Normally, people believe that blood is thicker than water, and I want a family member in there. And so 80%, I would say, of all trusts and estates are involved with family members. The key to that is what you see on the screen. The probate code is applicable to family members, it's applicable to trust companies, and it's applicable to professional fiduciaries. We all fall under the same probate code. And we all have to follow this book.
Is that a phone book? What is that?
No, it's not a phone book. It's the probate code.
Okay.
And so we all have to follow under that, and we're going to go through that today. Yeah. We're not trying to sell you on the idea of using a professional fiduciary or a trust company. What we hope to have accomplished today is that you can sit down with the person that you selected in your estate plan, and that you go through it with them so they understand kind of what to do and what is involved. Because most individuals have never done this before, and they're put into the position. And a lot of times they didn't even know that they were named in the position.
Yeah.
The other major folks who who serve as a fiduciary is trust companies. Trust companies will serve as a successor trustee, will serve as an executor in your will. They will not serve as your healthcare agent, and they will not, a lot of times they will not serve under the durable power of attorney. So just keep that in mind if you're looking at a trust company. Another thing about a trust company is, although they have to follow the code, the person that you're going to be talking to is not going to be the individual who is going to be managing your account. These are corporations, so they work from 8 o'clock in the morning till 5, and you'll have somebody as an employee paying your bills or authorizing payments, etc. So the good news about a corporation is that they don't die. They continue on. So I think having an individual be responsible is better than a corporation, but we'll leave that totally up to you. Yeah. As to fees, what do you pay your family member? It's totally open. It has to just be reasonable. So we usually say an hourly rate or a percentage. And if you haven't talked about it, you may want to, especially after you get through hearing what we have to say of all the liability and work involved. The professional fiduciaries, their fees range from anywhere from $75 to $450 an hour to a percentage of the estate. Usually the professional fiduciaries is between 1% and 2% of your estate. Corporations usually 2 to 4%. The cost of dying is not free. So on average, most individuals have to pay somewhere between 2 and 5% of their net worth upon death to get the assets over to the beneficiaries.
Yeah.
All right.
So, okay, well, so what we've done today is we've extracted from that book of code all the codes, well, not all of them, but the most important codes for successor trustees. And one of the things is there's another handout in your materials called Things to Do When Someone Dies. It is a list of things that keeps getting longer, it seems, every year, that we put together that you should go over with your successor trustee, or if you're going to be a successor trustee, you should look that over and see what items pertain to your particular situation. But it is more of a takeaway material, but a lot of the things we're talking about today will be on that. Let's look at, when you're drafting an estate plan, let's look at the different documents and remind ourselves, what are the fiduciary positions that each document has? Whoops, I went the wrong way. Hang on. Your drafting attorney will not finish this job for you until you've given him your fiduciaries for each of these documents. And who you choose is one of the most important decisions that you'll make in your planning, okay? So just so you know, we have, from week 3, remember we talked about the agent for power of attorney, and we've talked about the agent for healthcare directive. These are incapacity documents. They go away at your death, okay? With the exception of there is one post-mortem duty for the healthcare agent, and that is he or she has the legal authority for the disposition of human remains. Now, that may or may not be the same person as your executor or trustee, but just so you know, they probably should be able to get along. For the will, you have the executor, executrix, administrator. They're all doing the same job. And then for the living trust, you have the successor trustee. The job of the executor and the job of the successor trustee are very similar. The difference being is if you are probating a will during a probate administration, you will be court supervised, and there will be checkpoints in the form of hearings along the way to make sure that everything is up to speed. But as you know, we've talked about probate. It takes a long time. It's expensive, but you'll be doing kind of the same work as you would if you were a successor trustee who is administering the trust privately, and it's it's a lot. It tends to go smoother. Well, not always, but it's meant to go smoother than if it was in court. So today's session, we're talking a lot about trustees because we're assuming that most of you will have pour over wills and you will be having a revocable living trust that you will be executing. Now, Pete, as far as who you choose, it says 2 to 3 people, 2 to 4 people, are you recommending or are you talking about in succession here?
I'm talking about in succession. I think is rarely successful because you have to completely agree. And not only that, a bank, real estate, grant deeds, brokerage firms want both individuals to sign every single document. And if there's a disagreement, you end up in court. So I would recommend highly that you do it in succession and that you name a durable power of attorney, the will, and the living trust be the same person. You may want to consider somebody different for your advanced healthcare directive. We're going to be talking mostly about what happens after death. But can you go to the next slide there?
Yeah. I just wanted to quickly mention the conservatorship is not a document, but you may end up there if you have not properly planned your estate, okay?
So we're not gonna go into a lot of this, but go ahead there, Trevor.
Oh, yes, we are, Pete. No, I'm kidding. So one of the things is a lot of times we'll throw around trustee, but there's different stages of trustee. Okay, when you're alive and kicking, you have, I got this cool thing too. Okay, so when you are alive and kicking, you are the grantor, you are the beneficiary of all the assets that are titled in that trust, and you are in control of those assets. Okay, sort of a win-win-win situation. Even when you file taxes, you're using, for all your trust documents, you're still using your social security number and so forth. It is not a separate entity from you. However, if you live through a period of incapacity, let's say, you're still the grantor, you created that trust, and you're still benefiting from it, but your successor trustee will step in to manage those assets for your benefit. Hopefully, that should be the plan, okay? And then when you pass away, you're still the grantor, but your beneficiary will pivot to whoever you've named in your dispositive provisions of your trust, and your successor trustee will be administering that trust administration. But Pete, why is it so important when, I mean, people don't understand sometimes that the trust document is also an incapacity document. Yeah. Why is it so important when you're alive and kicking to choose the right successor trustee?
Well, because they're going to be doing everything for you. If you're incapacitated, you've had a stroke, let's say, are you going to stay at home, or are you going to move to an assisted care facility? Big decision. What bills are going to get paid, and how are they going to be paid? Who's going to take you to medical appointments? And, we use people like Leanne, who was in the medical care planning, as to determine, your medical needs. How about your investments? Who's going to control those? If you've gone through the It's Your Money course, it's kind of a wild world out there. Well, does your trustee that you appointed have any knowledge about investments? Do they have any experience managing a large sum of money? Who's going to do the income tax returns? And who's going to communicate with the rest of the family as to your status quo? To me, these reasons are probably the most important when you're considering who's going to be your successor trustee. Because when you're dead, I'm sorry, it's like you're not going to turn over in your grave no matter what happens. And everybody kind of wants to get along, and it's a selfish reason because they want the money. The beneficiary's number one question that I get when I serve as a trustee is how much and when. Yeah. And so it resolves itself. It might take a little longer than normal. The other thing too is that most individuals believe that if you have a living trust, then you're free from all the probate code rules. And that's not true. No. And that it's almost immediate. You die, 2 months later, here are your assets. Not true.
No, we'll learn a lot about that today. So we're going to be talking a lot about this period when your trust becomes irrevocable and you've passed away, and your successor trustee is going to be administering your trust. Okay, one of the most important duties you have as a successor trustee is to report and communicate to the beneficiaries. Okay, so there's a series of code sections there that represent that. One of the most important notices is the probate code 16061.7. That's the code, probate code. It's a 120-day notice to beneficiaries that goes out when a trust becomes irrevocable. Now, if you're a married couple and you have an AB trust or an AC trust, this will go out upon the death of the first spouse. However, if you just have an A trust or what is it? I love you trust.
Just a living trust.
Living trust. It'll go out at the death of the surviving spouse. Okay. Your trustee will have 60 days, that's what it says in the code, after the date of death to get this out. So Pete, what is this notice? Why do we have it? Who gets it? And do you recommend the trustee do this themselves?
Well, let me answer the last question first, and the answer is absolutely not. I've been doing this for a little over 25 years, and I've always hired an attorney to help me so that I make sure that I'm not in breach of one of the codes. This code section is a notice requirement that has to be in certain font size. It has to use specific language. It has to be in a very, bless you, you have to use a specific format. And every single person in the immediate family and every person that's stated in your trust has to receive this notice. And we call this the 120-day notice period because we're not going to do anything major in that 120 days, because the beneficiaries or anyone mentioned in your trust can object to the trust itself, that it was fraudulently drafted, or protest that whoever is named as the trustee, or there's a conflict of interest. This is the time for all the beneficiaries and those people who are named in that document to come out and say, hey, we don't like what's going on.
Yeah, this is the first evidence that the trust does not get distributed within 2 weeks, right? You have at least 4 months of notification period. So yeah, it also the trustee can help you make sure that it goes to all the right people too, because even if you've omitted an error explicitly, they will also get this notice.
Yeah, and the other thing too is that we see this more in males family members who become trustees, is that there is a duty to inform. Being a trustee means that you have to be transparent. There's no secrets. You have to be forthcoming. And, one of the big things is because in the 120-day notice period, not a lot of things should happen. Why don't we get into a little bit of pillow talk, Hey, your brother, I saw him last time, and, I don't think he's totally honest. Well, the trustee needs to keep the beneficiaries informed and let them know, hey, this is a 120-day period. Not much is going to go on. If you have any questions, please give me a call.
Yeah, you should always be available, and you should get some sort of system of communication. Pete, sometimes I meet with some beneficiaries, and they'll say, I know the trust says we have to do this, but Mom and I talked about it, and we decided, nah, we probably not a good idea to do that. Is that a violation?
Mom lent me $50,000. She told me that I didn't have to repay it.
Yeah. So this probate code section, it says duty to administer trust for what it says. Why is that even there?
Yeah. Sometimes you end up, a sibling stays in the house, and after the death that they've been taking care of their mother or father, and now all of a sudden you have to evict them. And because you got to make the rental or the house productive. The trust literally is the Bible, and so you've got
or any other holy book of your choosing.
Yeah, that is the probate code. The blue book and the trust. The blue book and the trust. What does the trust say that I can and cannot do? As a trustee, it's not your money. It's not your estate. You're just the interim between the person who's deceased and the next owner. And so this interim period is that you got to be fully disclose everything that you're doing, and based on the trust document, not what one of the beneficiaries tells you.
Guys, can I stop you for just a minute? Because we're getting a bunch of questions on this. So there's this 120-day rule. Is that from date of death? I'm sorry, 120-day. Is that from date of death or from date of notice? How long is it? Is it 60 days to notice?
60 days to send out the 120-day notice. In other words, you're not, upon the death, you're not going to go the next day to an attorney and say, send out the notice. Usually people wait 20 or 30 days. The 60 days is not, you know, if you go 90, nobody's going to object. But the 120-day notice, that's where you got to be careful.
Yeah, it's when you get the notice, the 120 days starts.
So it's receipt, not date of issue.
Yes.
Yeah.
Thank you.
So Pete, this next one, duty of loyalty. What do they mean by loyalty? Loyalty to what?
You have a loyalty to all the beneficiaries. So a lot of times people name a family member as a trustee, and the trustee is also a beneficiary. Well, the loyalty has to be to everyone else who is a beneficiary. It's not he or she can't step in and benefit themselves first. He or she can't use the monies of the estate in any capacity to benefit themselves. Everything has to be for the benefit of the beneficiaries. And if you breach this duty of loyalty, whatever happens, a judge can surcharge you 3 times the amount of the charges or the monies that was used from the estate.
Yeah. And that goes into this next one. So now you have multiple beneficiaries. This is a duty to deal with them impartially, okay? Now, it doesn't matter what percentage each beneficiary gets, you still have a duty of impartiality. And it's very common, Pete, as you know, that there are family member trustees that are also a beneficiary, right? And so that could lead to a sort of a minefield of conflict of interest there. That sometimes I get named as a co-trustee with the family member, and I will go through before I even accept the position. I'll go through all these codes to see if they're up to snuff, and they're, because everything that, if you're co-trustee, everything that the other co-trustee does, you're liable for. And
whether you know about it or not.
Yeah, whether you know about it or not. So I go over this, and a few years ago, I did this, and I got to this code, and the daughter who was co-trustee with me, she said she could not do this job. And I said, well, why not? And she said, well, I hate my sister, and there is no way I could be impartial towards her. And good for her. She recognized it and she resigned. But if there's any strife amongst siblings and you've named one of them as trustee, this is a very difficult thing to navigate, this particular code, because as you know, these things, the strife goes way back. It didn't happen a year ago. It goes back into childhood almost. So
it seems like when there's a death of both parents, it's kind of like, okay, now I can really tell you what I think of you. And they use the position as a trustee to punish one of their siblings.
Yes,
you know,
exactly. So the next code is a duty to avoid conflict of interest. And like we said, a family member trustee that's also a beneficiary, this is something they really need to look out for. What are some of, can you say any examples, and what are maybe some ways that family member trustees can protect themselves from this?
Well, I just happened about 6 months ago where mom died, and she had a year-old brand new Mercedes in the garage, convertible, really nice car. and had hardly any miles on it whatsoever. And trustee, and it was a blended family. And the trustee at the time wanted the car. And so he took the car. Says, I'm the beneficiary. And so I'm entitled to it. Wrong. That's a conflict of interest between his position as trustee and taking something for his own benefit. He breached the duty of loyalty, and he breached the duty to avoid a conflict of interest. He needed to return the car, which he did. The other blended family members said, we don't want you any longer as trustee. And that's how I stepped in as the successive trustee to manage the trust. Yeah. So it usually involves money. If you have a small business, you know, who is going to be running that business? What are they going to get paid? You have a duty to avoid even the appearance of a conflict.
Yeah, I mean, we have an example on the slide about loaning personal funds to the trust and then collecting interest. You put yourself, or you put your duty as trustee in a conflict there. What about, you know, there's a lot of people that have children that are real estate agents, and you know, and they want their, you know, of course they want that listing for the family home to sell. Let's say that was going to be granted. What sort of thing is there a notice of a, you know, a proposed action?
If any time you have, well, first of all, people believe that if they have a trust, they never go to court. Not true. About 20% do, and usually it's because of breaching one of these duties in the probate code. So in the situation of a real estate agent, well, they could earn 3% on the sale. And if you have a family member who is a real estate agent or is a special friend, it causes all sorts of conflict. What we usually do in those circumstances is we ask the attorney that represents the trustee, to do the notice of proposed action. It's NOPA, and sends it out to all the beneficiaries and says, I want Joe America to be the real estate agent, and there is a potential conflict because he's the best friend with the beneficiary. And if everybody who's a beneficiary comes back and says, that's perfectly okay, now the trustee has avoided a conflict of interest.
Yeah. So those are very important things to get out in front of and make sure you protect yourself and so forth. And if you have a situation like that with your trust, then as the grantor, you should also get out in front of that.
Yeah. Just to give you on the real estate area, because everybody knows a real estate agent. I don't know anybody who doesn't know a real estate agent. The bar to get into real estate is so low, you know, that everybody has a friend or a family member, somebody who has a real estate license, and they think it's easy to sell a property. Well, if it was your own property, it would be easy, because you have no duties, fiduciary duties. Yeah, but as a trustee, you don't own the house. And so disclosures, how much repair to do, do you put a new roof on? Do you sell it as is? What things do you do to protect yourself as a trustee and to make sure that all beneficiaries have been communicated with, so everybody understands that sale, because it could be the largest asset in your estate.
Yeah, well, let's talk about that. Taking control of and preserving trust property. This is one of the most important duties you'll do. And on that list of things to do when people die, there's a lot of items on that kind of are under this duty. So this requires the trustee to take affirmative action to take control and preserve trust property. Now we're going to break this down into 3 types of property: real property, real estate, tangible personal property, and financial property. So I'll start with the real estate. So when you, especially here in Orange County, like Pete said, our appreciated real estate a lot of times takes up the large majority of our trust corpus or principal. Okay, so preserving and taking control is really important, and it really has to start from very soon after death. But one of the first things you need in any trust administration is you got to get the death certificates, which usually take about 2 to 3 weeks after someone passes away. On all real estate properties, you want to get a date of death appraisal to establish your new cost basis. And when you file your tax returns, which we'll talk about later, your CPA is going to need to know that basis. Also, you need to investigate title, make sure that all the properties are titled properly in the trust. You're going to need to change the deeds with your name as trustee now, and you're going to need a death certificate for that. The attorney can help you do that. You're going to need to also file an affidavit of death of trustee. Attorney can also help you do that. That's with the county where the real property is, and you'll need a death certificate for that. You need to investigate the insurance on the house. How long, if someone dies and then the house is going to be vacant, how long is it going to be insured under the current policy? Do you need to take out a vacant house policy because it's going to lapse or expire? You need to forward all the mail to the trustee. The trustee needs to go to the post office website and forward the mail to the new address so they get all mail and they can get all this information. They need to investigate the security of the house. Perhaps most likely change the locks because we don't know who has keys and we don't want anyone just going in there whenever they want.
You mean I can't go into the house and say, Mom promised me that I could have that painting on the wall?
Nope. And you're going to talk about the tangible personal property, but you also want to maintain the appearance, make sure the gardener is paid and everything doesn't look abandoned or vacant. Okay. And then we talked about choosing, making sure you choose a real estate agent that understands selling a property that's in an irrevocable trust. A lot of them do not understand the difference, and it's a big difference. If there's rental or commercial properties, investigate the leases. How long are the tenants there? Maybe you'll have to arrange for property management services, but those are all these things you need to do, and it's your duty to do. Now, Pete, these houses, when I find them, they're full of furniture, paintings, art, vehicles. What do we do with all this stuff?
Well, personal property is probably touches most of the nerves, from jewelry to watches to special tables. Sometimes family members argue over the personal property, no matter how big the estate is. So personal property is huge. One of the things is that we usually check on, is there assignment of the personal property to the trust? Because if there isn't, then there's a question whether or not I have to have an executor hat on, or do I have a successor hat on as to preserving that property. And I can't just let everybody just take the property if I am the one in charge. So my recommendation is make sure that you take a look at your trust agreement to see whether or not, one, you have an assignment to the trust of your personal property, and two, do you give, which I recommend highly, the trustee final authoritative dictator control over how the assets are distributed if the beneficiaries cannot work it out themselves. And so we try to be fair. We try to do a lottery. We do, you go into one room and put little pig slips on what you want. There's all sorts of methodologies that we use to keep it fair. But the bottom line is that if the trustee doesn't have control, then it's a mess.
Yeah, and yeah, and also, you know, that assignment's an important thing because a lot of people don't use them. And it's the only part of your trust that you can write in by hand, cross out, change your mind, do all that. And it really helps the trustee if you can keep that current.
Yeah, I want to mention one other thing because we're getting into all sorts of negative things that can happen. You know, in most estates, with the lousiest written trust agreement, and I've seen lousy trust agreements, everybody gets along and everything goes smoothly. Okay? Why? Because everybody's not at each other's throats. They're helping each other out. Hey, you take this, I'll take this. What can I do? It's those situations where, you know, the family members don't get along and a piece of personal property becomes, hey, at 16, you didn't let me have your dress for the prom. So this now I'm going to get even with you.
Yeah, and no, it's very emotional time. People are grieving, you know, we've just lost a loved one. So things can go sideways just on the smallest detail. So you just got to make sure that you're doing everything correctly.
And the preserving of the property, you know, it's, you've got to take measures to keep the property up to keep. And that goes for, if it's a special gun or a special painting, you know, you don't want to see that on the Antique Roadshow.
No, you don't. And you don't want to see those walking away at the funeral or wake.
Yes.
So also let's talk about financial property. A lot of your trust property will be titled in checking accounts, savings accounts, brokerage accounts. You, as a trustee, will need to obtain a new tax ID for the now irrevocable trust. Your social security number died with you, okay? So you have to get with that. You have to take the statements that you've got in the mail, the legal documents, the trust and anything accompanying that, and the death certificate along with the new shiny new EIN or tax ID number. And you have to take these to the institutions and what we call marshal these assets into now this new irrevocable trust with you as trustee. And every institution's got their own way of doing it. And some are more efficient than others, but just understand that you're going to have to need all those things when you try and get those marshaled. And also you need, if there's any other, closely held businesses or LLCs, you'll have to, or anything like that, you'll have to handle those too.
Yeah.
Pete.
You got to put these in a separate bank account.
Yeah, that's what this next probate code here, I mean, which just kind of goes along with what we're saying, is a duty to keep trust separate and identified, trust property separate and identified. Why is that even in the code?
Because upon death, no one owns really the property. And as the trustee, you're responsible for managing that asset. And so all the beneficiaries will want to know what's the value of the assets of the date of death. They want to know everything that's been paid, and they want to know all the income from the assets during this period of time when nobody owns it.
Yeah, and so if you've commingled that with your own personal bank account, even if with the best intentions, it could really become a messy situation. So that's just very important not to do that. Okay, the duty to make trust property productive. I'm going to talk quickly about just real property, and then you're going to talk about the financial property. Like you mentioned earlier in the presentation, There's often times where someone will die and there are either beneficiaries or children or people living in the house. And I can't tell you, I mean, it's very common. And so unless the trust explicitly says that they can stay in the house for X period of time and the trust will pay expenses and so forth like that, they need to pay fair market rent or they need to be evicted. I have had this year alone 2 evictions of family members from the trust property that they were occupying. Okay, and it is an expensive and it time consuming and it upsets all the other beneficiaries. Okay, so if you, I mean, and I'm a neutral third party doing this. If you put a sibling in a position of evicting their brother or sister, you are in a you may have just irreparably you messed up the relationship, right? Between, I can never say that word.
Irreparable harm.
Yeah. It's just a real, I mean, you really have to be careful of situations like that because you've destroyed the sibling relationship. And so, but I've seen it happen. Now, Pete, if in regards to financial property, in fiduciary investing, does the trustee have a duty to make, you know, the bank accounts and brokerage accounts productive?
Yeah, absolutely, yes. But there's 2 different ways of looking at this. One is in the short term. Most times that we're involved from anywhere from between 7 to 11 months. And so this is not a long-term investment. So, but we can't just leave a house vacant. We can't leave $300,000 in a checking account earning no interest. It has to be productive. So
now, what about a situation? Because we've talked about subtrust. Like, let's say you want to leave money to your grandchild who's in his early 20s, but you want your child to be the trustee for 15 years, and then your grandchild can be either its own trustee or so forth.
Okay. Unless it's a parent to child thing, I would never recommend one child to be a trustee for another child because all they'll talk about is money and you'll ruin their relationship. However, it's done on a regular basis. So here are the rules for a long-term trust. You got to prudently administer. What does that mean? Well, you got to establish risk and return expectations. And again, we all in professional fiduciary services use fee-only registered investment advisors who lay this out in a written form to make sure that all the beneficiaries and anyone who's interested know that we're prudently managing the money. What are the prevailing factors? What is the life expectancy of the person? What is the bond market doing today? What are the expenses that for the professional help? Are they reasonable? Did we delegate prudently? Did we just pick out someone out of the blue? Did we check with broker check to make sure that the individual didn't have any disclosures? You have a duty to prudently delegate your duties. Duty to independently monitor. Are you looking at the returns, the quarterly reports? That's one of the reasons why we're a trustee. We never use brokers because brokers don't do the quarterly monitoring of each individual's portfolio. But you have a fiduciary duty to invest properly.
Yeah, so it's not like you can just do whatever you want because you're the trustee. We are governed by this. The California State Legislature has literally put this Uniform Prudent Investor Act into our probate code to guide our trustees of what we need to do.
Well, family members who are trustees, they can't put monies into their own business. They can't put it into a friend's business. You know,
Yeah,
it's not their money. You know, it's you've got to follow these rules.
Yeah. So that gets us to an accounting. Now, duty to account is probably one of the most breached codes. Wouldn't you agree? I mean, I think.
And one of the most important.
Yeah, and one of the most important. So from date of death, or, you know, if you're a spousal trustee administering, let's say, a bypass or a marital trust, but let's just say just a regular survivor's trust, you will need to account for all transactions, income and expenditures from date of death. You really need to establish a system, because remember, you are going to have this job for 6 to 12 months, maybe longer. Okay, I always try to get it done quarterly and get everything out to them so they can kind of see it as we go. But sometimes that's, you know, you're not able to do that. So 6 months or at least annually that you need to get this done. Now, if this is not your wheelhouse, if you think that this is something that is better to prudently delegate to someone that is more skilled and has expertise in this, that's okay. But it's just important that it gets done properly. Now, final distributions, okay? You are going to provide every beneficiary with a final accounting and a consent that they agree to it, and there's a proposed distribution table and everything. And then your attorney should be helping you prepare all this. But your record keeping is so important to making sure all of this goes smoothly, because you know, that record keeping is your sort of file of what you've done.
Yeah, the court it's not like the court is going to assume that you've been correct. In fact, it's the opposite, because as a fiduciary, you have the other person's best interest. So if they accuse you of not providing a good accounting, not preserving property, not being loyal to the trust, the fiduciary has to prove that they did comply with the code. So yeah. It's unless you have special language in the trust, the burden of proof is on the fiduciary that they did it correctly.
Yeah, you have to, you're right. The burden of proof is on the fiduciary. Now, also going back to compensation, I mean, this is not a specifically to accounting, but I think it's important to include here. If you are paying yourself, or if your trustee is getting paid, they should be accounting for their time and sort of the description of what they did. Don't you agree, Pete? Like,
yes.
Yeah. So I that's another sort of, it's not a formal number accounting, but if you have an invoice that you are invoicing the office of trustee, which you're the trustee, and you're giving yourself an invoice, you should have all that written down, and it all adds up.
You know, and if you have more than one child and you've named that one child as to be the trustee, please let the other children know that it's okay for him or her that you've chosen to pay themselves.
Yes, very important.
There are so many family breakups when the parents die, and it's over money. And so this is a crucial period that you want it to go smoothly for the rest of your family.
Yeah. And also for one of the reasons to keep such a good accounting system and stay organized is when the trustor dies, or the grantor, excuse me, same thing, but the grantor dies, that year, you're going to have to file, the trustee is going to have to file his or her personal income tax returns for the decedent, the 1040 and the 540, They're going to have to file a fiduciary tax return for the trust, a 1041 and a 541. And then they may even have to file a 1041 and 541 for the estate. Okay. And then if they die and they've died and their worth is over the estate and gift tax exemption, they're going to have to file another 706 estate and gift tax return. So you could possibly, conceivably, have 7 tax returns to file in the year of the death, right? And if your accounting system is all messed up and disorganized, this would be a nightmare, okay? So that is one of the things. So all the things we've talked about before, you know, taking control and preserving trust property and keeping things separate and identified, this all comes back when you're trying to keep the accountings right and under control.
So pick someone in your family who is somewhat anal retentive.
Yeah, it does. It does help. It does help. Or delegate it to a competent professional that can help you.
Yeah, which is really important, because I think lay people are reluctant to hire experts, and they're thinking that it's going to cost extra money and they're not used to paying those kinds of fees. But we use them all the time. If we have a $50 million commercial real estate shopping center, we're not going to be managing that shopping center. We're going to be hiring a professional commercial manager to manage that property. If it's a business, we're going to be hiring a CEO to run that particular business.
Right.
The trustee has a CEO hat on that you need to understand and know quality, ethical professionals who will do a good job for a reasonable price.
Pete, let me ask a question. So, and I want to come back to this slide in terms of duty to account to the beneficiaries. How often do the beneficiaries, should the beneficiaries be given at a minimum? What's the requirement? Is this annual? Is it 6 months? Is this?
The requirement is by the probate code once annually. So,
and if they don't do it, what can I do because they didn't give me one?
Then they're in breach. So you have the beneficiary can go to an attorney and you can sue the trustee because they breached their duty to the account. This is the #1 duty that's usually breached by the fiduciary.
Yeah, because if you wait a year to do an accounting, it's going to take it's going to be that much harder to do than if you did it less frequently.
One more add-on to that is that usually what happens is, or talk to the fiduciary's attorney and say, can you get me an accounting? You know, try to stay out of the courtroom as much as possible. But this is a major breach. It's very common. And you want to try to see if you can work it out. But the duty is at least minimum once a year.
If a family member is the trustee, are they able to charge a fee?
Yes.
Who decides the fee? Is that statutory?
No, it's up to, the probate code says the fee needs to be reasonable.
Do they have to submit an invoice then to themselves and keep track of the time, as you said a minute ago?
Yeah, and you know, they can't, you know, if they do it themselves, for example, and a CPA charges $300 an hour and would charge $10,000 to do the accounting, and they come back and bill 20 or 30,000, you know, they're in breach.
And there's no requirement to go to the court to get approval for this, but if you're unreasonable, you may get sued for it.
Yeah, you can always go to the court to get the court's approval. And in this litigious society, sometimes if the beneficiaries don't get along with one another, they're complaining. I have gone to the court and asked the court to approve the accounting because the beneficiaries are are not
Difficult.
capable of approving the accounting. So the court is always your last resort, but everything goes by the probate code.
Yeah. Yeah, and that's what they'll be looking at, the probate code. So Pete, let's talk. So the family member trustee, he or she's done the best job they can given their skills and their competence, but yet they still see themselves in front of the judge after being sued by their sibling. How is the person going to be judged by the court in this situation?
Well, it's by this code, the standard of care, and that is that trustees shall administer trust with reasonable skill and care and caution under the circumstances, then prevailing that a prudent person acting in like capacity would use in that enterprise or in that conduct. So it's not from an expert point of view, and it's not from 2020 hindsight. The judge is going to look at the circumstances at the time to determine whether or not there was a breach. And it usually involves around money. I didn't talk to the beneficiaries. I put it in my own personal account. I took some personal property for myself. I didn't provide any accountings. It's those kinds of things. Yeah. And the more money you have, the more children you have, the greater likelihood that there might be a problem.
The more marriages you have.
The more marriages you have, yeah.
Yeah, so, but you don't have to be an expert. But no. If you do have special skills, let's say you are a CPA and you're acting as trustee, well, the court will say, well, your accounting is terrible. Why? You're a CPA. I mean, they will look at those. But if you're just, like you said, Pete, they will look at this
prudent person.
Yeah.
Let's go to the next slide.
Yeah. So this is this is the final slide. So what we'll do, Pete, why don't we go two at a time? Why don't you do the first two, and then these are qualities that we think make a good trustee.
Okay. A lot of individuals pick somebody in the family and they're not close. And what I mean by close is in, I'm using proximity.
You're jumping to number 3.
That they don't have, I know, I'm stealing your thunder, I'm sorry. But they don't really have the time to put into the job. You have to appear in person at a bank to put a bank account in your own name. Many brokerage firms require you to be there in person. So it takes 7 to 9, 10 months. You need the time. 2 is the desire. It amazes me the number of people who put one of their kids in as the trustee without talking to them. Maybe they know something about their brother or sister that they don't want to deal with and don't want to be the trustee that you just don't know. Or maybe after you go through some of the things that we talked about today, they go, I don't need this in my life. Or they're a CEO of a company or a CPA practice, and they go, I got plenty of liability. I don't want to do this. Talk about proximity and organization.
Yeah, so proximity is very important. It's not, I mean, can you do this from out of state? Maybe, but I mean, do you have, the time and desire to fly and back to the state, to California and handle this for, 2 or 3 months at a time while you got a very busy life over there? The proximity helps a lot when doing a lot of this work. But one of the things that's really important, though, and we talked about earlier in the presentation, that if you are stepping in as trustee while the person is incapacitated, then they must be proximate. It's almost impossible to do this job properly for someone who's incapacitated from out of state or even far away in state. Organization, we talked a lot about that in the last slide about regarding accountings and stuff. It's very important that you are organized and you don't procrastinate, some of these duties that might seem kind of tedious and so forth?
The ability to delegate and to be communicative, I would probably say the communication issue is probably absolutely number one. But the ability to delegate, you're going to need an attorney. Okay. So don't do the 120-day notice yourself. Don't do the final release letter and accounting yourself. You need to spend the estate's money on hiring good professionals.
So you wouldn't want a control freak in you as your trustee so much.
No, you need to delegate. From gardeners, construction people, caregivers. There's just no way that you can do it all yourself. Communication is absolutely key. That's where that pillow talk comes in. I usually try to get brokerage statement out to the beneficiaries, bank statements out to the beneficiaries, to keep completely transparent as much as possible as to what is going on. Anybody asks a question, we try to answer them immediately, because the lack of communication creates resentment. Resentment turns into finding an attorney, and there's plenty of attorneys out there that will take a disgruntled heir and sue the fiduciary, because the money that gets paid to that attorney comes out of your trust.
Yeah, they almost just have a checklist and they go through these codes and see what you've breached.
Yeah, exactly. So communication covers an immense amount of sins.
Yeah, okay. I'll do the last two: presence. Okay, so, when someone passes away and you're the successor trustee, okay, you're walking into a situation where people are grieving, people are wanting answers. They want to know what the game plan is, and your presence goes a long way. You don't want to bully in that situation, but you also you don't want a wallflower who's not going to do all the things they're supposed to do, and no one really has much respect for what they have to say. That initial meeting, at the kitchen table with the beneficiaries and trying to get them to follow your plan and so forth is a very important part. So if they have a good presence and people respect them and respect what they say, that's a good thing. Transparency, one of the best attributes of a trustee is being transparent. You do not want a BS artist in this job. You want people that mean what they say, that are forthcoming with the information and communicate. I think we've lost Pete. I don't know where he went. Don, are you still there? Maybe they've lost me.
I'm still here. And
okay.
Trevor! Trevor's like, oh shit, I've lost. Excuse me. Yeah, Pete dropped off. The other day, Pete was having a problem with electricity. As a good trustee, he's apparently failing to pay his electrical bill. And so we don't know why, but Pete keeps dropping off and occasionally comes back in. So this is not the first time Pete's disappeared on us. I'll jump back in and since we're at the end, I can jump right back in.
Yeah, no, we're good. So that was the end of the presentation. I think we have about 5 or 6 minutes left for questions if there's any, but here's on the final slide here that we have our website and if you have any follow-up questions, you can email me or Pete directly. We'll get right back to you. And then if you want to set up an appointment, we meet with people free of charge to discuss, the execution of their estate plans. So we're like the executioners. Kidding, that's a bad joke.
I was going to say, no, let's not have you be the executioners. You are the ones who execute. That's wrong too.
Yeah.
You carry on. Yes.
So is there any questions?
There have been numerous questions along the way. And one of them that just came up now a moment ago was, so we talk a lot about mustering the assets and making sure everything's there and getting properly valued. let's talk about real estate for a minute. So I have in Mom's estate, there's a house. I need to have that value. Do I have to hire an appraiser?
No, you can get a broker's opinion. You just need to come. So
it's a $2 million house. Should I do that, or should I pay for an appraisal?
I would pay for an appraisal. They cost about $350 to $400. If it's a $2 million asset, I think you'll protect yourself as trustee if you just, you can use the trust money to pay for this. It's okay, and get a proper one. But you just need to come up with a number in a reasonable way.
And if I'm looking at financial, my investment, the investment portfolio and everything else, can I request from my broker a date of death statement? Would that work? Or do I have to go in and price all of these things independently?
You would ask your broker or your financial advisor to help you establish that cost basis for the date of death. And in recent years, they've passed some laws that have made it easier for them to do that. So I recommend you use them to do that. You can kind of do it yourself if you look at your statements on the day that, or maybe look up every security of the day of death, but that's just a lot of work.
I'll age myself. I remember when we used to save the newspaper from date of death because it had the stock prices in it. I'm aging myself, and that's okay. There's a question in terms, we've talked a lot about communications. Is there and I don't have the 20 question list in front of me. What do I have to communicate? For God's sakes, I'm doing this annual financial. That's all I need to do. No.
No, you need to, what happens is you'll get a beneficiary calling just saying, hey, when are you expecting the distribution to come or whatever? And so you have to say, well, you have to tell them the steps. Look, before you get the distribution, you're going to get this accounting, and I anticipate it to be in a month's time or 2 months' time. Never give absolute dates like, I expected October 1st. Don't do that, because it almost never lands. Because remember, a lot of times you'll do all this work, you'll do all this accounting, you give all the books to the attorney to help you create this final accounting and consent to the beneficiaries, but the attorney may not, may take them a couple of weeks to turn that around. So, and it's kind of out of your hands by that time. You're kind of waiting on them. So you never want to give exact dates.
If it's just, okay, for the sake of discussion, Mom dies and it's my sister and I, and we agree on everything, do we really have to wait this 120 days? We know there are no liabilities.
Well, you can make that call, but remember, you're taking that risk as the trustee.
Right.
I would never do that as a professional.
No, understood.
And there's many times where I know there's nothing will happen, because you're right. I don't foresee any issues, but it's just good practice to follow the probate code. A lot of times you can start doing, like, you can start selling the house. If you don't think there's any issues, you can start marshaling assets into, let's say, a money market savings for distribution. But I would hesitate to say you can distribute. Okay.
So for the sake of discussion, here are the liabilities in the trust or the estate rather. And I know it's come up in other sessions. Mom was broke. She had a world of debt. Do I have to pay all that stuff? Pete's back.
Personally, no, not from your personal account, but okay. So creditors. Oh, Pete, there's Pete.
Hi, Pete.
Pete, we're on. We got a question about creditors.
So do I have to pay my mom's debts?
Yeah. Do I have to pay my mom's debts?
Not out of your personal account, but you are responsible to pay them from the estate account. Having said that, I always pay creditors last, especially credit card companies, because credit card companies will basically, towards the end, you owe 50 cents on the dollar to a credit card company, but you never pay those creditors first, except for your gardener, the lights for the house, those kinds of
mortgage. Yeah, you got to pay the mortgage. But yeah, like medical bills, credit card, you can kind of wait till till you've got
What are they going to do? Come after you? I'm kidding.
Exactly. Well, I've had companies call and say,
sure,
don't you care about your credit rating? I said, the person is dead. You know, so they'll try to get anything out of you to try to see if you can pay the credit card bill. I want to just mention back, sorry about my power went out, but in picking someone, age is important as well. I'm 71 years old. Trevor, how old are you?
48.
48. So for a 55-year-old who wants me in their trust, is not a good idea. Same thing if you're going to pick a friend or if you're going to pick one of your children. Age is important. The other thing that's really important is character. If one of your kids have got a DUI or has got a bankruptcy or has had a drug problem or is in and out of jail, I don't care how close you are, it's probably not a good idea to name them as a trustee. We have a group of 7 individuals that are professionals. I picked them because of their good character, and I can teach them all the other basics. So if you pick somebody in a family who has a good character, they have ability to communicate, they can delegate all the things that need to be done, and you're going to be fine.
Yeah.
Thank you very much, Trevor. Thank you very much, Pete. Next week, we're doing a wrap up, and part of what we're going to do is go through all the questions that we have had over the 7 weeks leading into next week. And if there are themes or ideas or something else we think we should cover, that's part of what we will be covering next week in terms of what goes on. So we highly recommend, and yes, Trevor, you can stop sharing just so our pictures are bigger. Just scary. So that's what we will be doing next week, and hope that you come back with us. And we had a good turnout today and appreciate it. And we'll see what happens in the voting and the elections by next week.
Yes.
Anyway, thank you very much for being here. Thank you, Trevor. Thank you, Pete.
Yeah,
and
thank you,
we
John.